Good evening. Well, tonight we are honoring the 13 fallen service members who lost their lives when a suicide bomber detonated explosives at a Kabul airport as American troops were helping evacuate civilians. And good evening, I'm Lindsay Keith. Welcome to Spicer and Company. Sean has the evening off. Well, the attack 1 year ago today was the single deadliest enemy strike against American forces in Afghanistan in a decade. And we have an all-star military panel standing by to reflect on the anniversary, the Biden administration's botched withdrawal, and the state of our military today. But first, the Justice Department has released a redacted version of the affidavit from the FBI's raid on former President Donald Trump's home. At least 21 of the 38 pages are mostly or fully redacted, so we did get a little bit. The affidavit sheds new light on the details of the investigation and the probable cause for the search. According to the affidavit, the investigation covers the improper removal and the storage of classified information in unauthorized spaces, as well as the unlawful concealment or the removal of government records. It goes on to say that the investigation began as a result of a referral from the U.S. National Archives and Records Administration back in February of this year. It also reveals that 14 of the 15 boxes taken from Mar-a-Lago in May of this year contained 184 classified documents. Of those, it shows that 67 were marked as confidential, 92 were marked secret, and 25 were marked top secret. And the affidavit concludes that the anonymous special agent wrote this. It says, "I submit that the probable cause exists to believe that evidence, contraband, fruits of crime, or other items illegally possessed in violation will be found at the premises." Okay, so what does this all mean? Did we learn anything new? Let's welcome in an expert, Harvard Law School Professor Emeritus and Newsmax analyst, and the author of The Price of Principle, Alan Dershowitz. Professor, welcome to the show. I have been waiting all week to talk to you about this. I'm very excited to have you here because you are the perfect guest, and I'm sure Sean is sad that he's missing out on this one. But let's just start off. What did we learn from this? Because when you look, like I said, 21 pages of this are redacted. I was surprised that not all 38, but what did we learn today?
Well, I learned a great deal. I learned that a very strong case was made for issuing a subpoena and not a search warrant. After all, they had all this information back in February. They had enough to get either a subpoena or a search warrant back then. There was obviously no rush, no urgency. Even after they got the search warrant, they waited 2 days to effectuate it. So I think two conclusions are clear. Number one, there was probable cause, but there was probable cause back in February. So Judge Reinhart didn't do anything wrong. But Attorney General Garland did do something wrong. By his own standards, he should have persisted in effectuating the subpoena and not going for the much more intrusive search warrant. There was just no reason for that. The other thing is the search warrant was very broad and covered almost everything. I think it probably violates the provisions of the Fourth Amendment that provide for specificity. And the final thing is it does provide enough evidence to permit the Justice Department to indict President Trump if they choose to do so. But I don't think it meets what I call the Richard Nixon and Hillary Clinton tests. That is, you don't indict a possible future presidential candidate unless it's so clear and so overwhelming that even members of his own party support it, the way they did Richard Nixon's impeachment and possible prosecution. And second, you have to show that this is qualitatively different than the case against Hillary Clinton, which didn't result in an indictment or a prosecution. I don't think those standards were met.
Okay, so a lot of this stems from the Presidential Records Act, that the president has to give back government documents, records, classified information. But we've talked to you about this before, that it's not incriminating. So has something changed? Are they trying to make the case that it is incriminating?
They are. They're trying to do it under the Espionage Act of 1917, the most anti-civil liberties statute passed in the 20th century, and probably the second worst statute in American history after the Alien and Sedition Act. And every liberal I know and civil libertarian hates the act. Now that it's being used to get Trump, they love it. They want to expand it. They want to make it even broader. But there is a possibility of, they mention it in the affidavit, they mention it in the warrant, that section of the Espionage Act that prohibits anybody from possessing material of this kind. The problem is that that was true also of material possessed by other people who haven't been prosecuted. And the appearance of justice does not permit an attorney general appointed by a future presidential candidate to indict his opponent without there being overwhelming evidence and a consensus by the vast majority of Americans that this warrants prosecution. I don't think that standard has been met.
Okay, so let me go back to you brought up the timeline of all this, and the affidavit details that timeline, that the National Archives sent this referral for the investigation back in February, on February 9th. But they didn't make a request for any of the missing documents until May 6th. So it seems like if these documents were so important, it was such a national security concern that they would have moved more swiftly, or is there something in here that maybe lets us believe they found out more information?
There's nothing in the affidavit, at least the unredacted portion, which would in any way justify a rush to search after so many months had gone by without a search. There was no evidence that he was about to hand them over to North Korea or to China or to Russia. The evidence was that they've been there all that time. Some of them were handed over, some were not. There is a potential violation of technical statutes, but not justifying a search warrant on a former and potential future president. It justifies a subpoena, and that's what should have happened. And this affidavit strengthens the case for a subpoena and weakens it for a search warrant.
So when you look through this affidavit, what isn't redacted, it really talks about the ongoing investigation. That's why they wanted to redact so much information, to protect these witnesses, to protect agents and so forth. So it's ongoing. We have this redacted version. What is next in this case?
Well, I think there'll be negotiations now between Trump's lawyers and the Justice Department. He has not been named as a target of any prosecution. I don't think he will be named as a target, but you never know. It really depends on what's in the redacted material. We just don't know the answer to that. Too much was redacted. I think too much of the strategy and the theory of the case was redacted. It was perfectly proper to redact names of confidential informants. I don't think you need to redact names of FBI agents. Many of them are known already. But government always over redacts and always over classifies. And civil libertarians generally ought to be in favor of disclosure. But when it comes to Trump, civil libertarians turn everything on their head and get trumps every civil libertarian notion that civil libertarians have advocated for everybody else. So don't listen to old civil libertarians who have now changed their mind. Look back at what they said before Trump was under investigation and see if what they're saying now is consistent with what they've said in the past. The answer is it's not.
I only have about 30 seconds left, but President Trump came out with a truth today saying that he thought that the magistrate Reinhart should recuse himself from this case. But you're saying that he had probable cause to give the search warrant. So would you agree with him that he should recuse himself? 30 seconds.
Absolutely should not recuse himself. Every single magistrate judge would have granted a search warrant based on the evidence in this affidavit. That's an easy case. Reinhart was right. Who was wrong was Garland by his own standards. He should not have sought a search warrant, but the judge had really no discretion. There was probable cause in this affidavit. Maybe he should have narrowed the search beyond that which was sought by the government, but he certainly should have given the warrant, and he should not recuse himself.
Professor Dershowitz, always good to see you. Thank you for helping us shed some light on this, even though there's so much redaction. Really appreciate your insight here this evening.
Thank you.